Hello everyone, this is Advocate Pawan here. So today we'll be learning all the important current affairs, recent judgments, which is required for your exam perspective in a detailed, elaborative manner. We will be covering it up. So make sure that you're taking down the notes for your upcoming exam. These are the most important and the most repeated kind of questions. As being said that, let's start with your preparation. Okay, let me give you the situation, then I'll explain you the concepts. Okay, for example, Pawan files a suit for the land ownership. During that case, Kamal buys the same land for Pawan's uncle, knowing the case is still running. Okay, Pawan files a suit for land ownership. Okay, I'm filing a suit for land ownership. During that case, Kamal buys the same land for Pawan's uncle, knowing the case is still running. Okay, he's knowing that the case is still running. Later, Pawan wins. Kamal cannot say I am protected under section 53A because he knowingly entered into the deal during the ongoing litigation. So very simple, when there is an ongoing litigation, if you purchase a particular land and in case if you do not win that particular case, if it's winning by another person, then that person holds the complete ownership, not you. Very simple. Now let's look at the example. Okay. During the pendency of a suit concerning the suit property filed by the respondent, an agreement to sell was knowingly entered by the appellant with the respondent's father making an advance payment. The suit was decreed in favor of the respondent. However, the appellant claimed protection under Section 53A of the Transfer of Property Act 1882, stating that his rights over the suit property must be protected as part of part performance of the contract. Now, let me just quickly take you to what is Section 53A. Okay, it says that Transfer of Property Act protection not available if the person entered into an agreement knowing about the pending litigation. This is what basically 53A it says. So the answer is very simple. It is option B because no, Section 53A of the Transfer of Property Act cannot be invoked by a transferee who enters into an agreement during the pending litigation, especially when the transferee is aware of the litigation. Clear? I hope this is very clear for you. Okay, very simple. If there's an ongoing dispute, if you purchase a particular land, and what happens if you're losing, you are losing that entire land. You cannot seek protection under Section 53A. Very important for your upcoming exam. Now let's look at the second example. Okay, uh, Pawan's bike is stolen. Instead of going to the police station or the SP, he directly goes to the magistrate asking to register an FIR. The magistrate says no. Kamal must first go through section 154.1 and 154.3 before coming to the court. Very simple. So you cannot go directly to the magistrate. First, you need to go to police station. If they rejects, then you can go to the superintendent of police. Then if it's rejected, then you can go directly to the magistrate. Okay. Whether a magistrate can direct a registration of FIR under section 156 clause 3 of the CRPC, even if the informant complaint didn't exhaust the remedies available under clause 1 and 3 of the section 154 of the CRPC. Find out the most appropriate option. It is basically option C. A complainant must first exhaust the remedies under section 154 clause 1 and 154 clause 3 of CRPC before approaching the magistrate under section 156 clause 3 of the CRPC. Very clear? Yes. Third question. Let me go to the situation, then I'll explain you. The court tells Kamal not to sell a land till the case is over. Kamal still sells it secretly. Later, even if that injunction is cancelled, Kamal will still be punished because he violated the order when it was enforced. So if court is telling you do not sell the land, now case is happening. If that guy goes and sell that particular land, can he be punishable? Yes, he is punishable. Under which case it was decided? Srimati Lavya C and ANR versus the Vittal Guradas Paisins deceased by the LRS. This is a very important case law. Please do learn it. Let's see how in your exam they can ask you a question. In a civil suit, an injunction restraining the defendant from alienating the suit property. Despite this, the defendant sold the portions of it 2007 to 2011. This is a real case, okay? The plaintiff filed an application under Order 39, Rule 2A of the CPC for willful disobedience. Later, the injunction was dismissed. Can the defendant be held liable for violating the order while it was in force? The answer is think carefully. The answer is the defendant remains for violating the injunction order while it was enforced, even if the injunction suit was subsequently dismissed. I hope this is very clear for you. Now, fourth question. Let's read it very carefully with an explanation. The Supreme Court recently observed that an application filed under Section 47 of the CPC relating to the okay, wait, before I read it, let me read the example. Okay. After Pawan gets the court decree, Kamal says he is the tenant. The executing court must treat Kamal's claim like an Order 21 Rule A 97 issue, not just dismiss it because it involves a right and title. So very important, even though after getting the court order, If Kamal is saying that he must he is a tenant, the executing court must treat Kamal's claim as an order 21. Okay, they must treat it like an order 21 rule 97 issue, not just as and dismiss it. Okay, because it involves right and title. So if you are a tenant, that needs to be respected and protected. Let's look into the question and then let's read it. Okay, in a civil suit, a decree granted the plaintiff possession of a property. The defendant later filed section 47 of the CPC application claiming tenancy right as a bona fide cultivators over the suit property. The executing court dismissed it, stating it couldn't decide the title issue under 47. On appeal, the defendant argued that their application should be treated under Order 21, Rule 97 of the CPC, which permits such adjudication. Find out such most appropriate option. The answer is very simple. It is option D. The defendant's applications under Section 47 CPC. Okay, let me tell you what is Section 47 CPC first. Application raising property rights after passing of decree to be treated as an application under Order 21 Rule 97 of the this one. So I hope this is very clear for you. The defendant's application under Section 47 CPC should be treated as one of the Order 21 Rule 97 of the CPC because it raises the question of rights, title, and interest of the properties. An executing court must reclassify the application under Section 47 under Order 21 Rule 101 of the CPC due to its inability to decide the question of right, title, and interest in the property after passing of the decree under Section 47 of the CPC. Very simple. I hope this is very clear for you. Even though a final decree has basically been passed, but later point, if the tenant is basically raising a question over it, the court must still be respecting it under the so and so respective kind of order and rule. Okay, let me go through the examples. Okay, very simple. Kamal's company check bounces on July 20th. Okay, Kamal's company is basically check bouncing on what? On July 20th. But IBC moratorium starts July 2025. The notice is sent on August 6th, meaning cause of action begin after the moratorium. Hence, Kamal can't be prosecuted under Section 138. Very simple. Okay. Kamal's company's check bounce is on July 20th. So July 20th, they're having a check bounce. But IBC moratorium starts from July 2025. Okay. So IBC, okay. IBC has very clearly said that they will be starting only from July 2025. The notice sent on August 6th, meaning cause of action began after moratorium. Moratorium. Hence, Kamal can't be prosecuted under Section 130. So he cannot be punished under 130. Let me just tell it to you in a simple explanation. The Supreme Court has explained that the cause of action for the offences under Section 138 of the NI Act arises not on the dishonor of the check, but when the amount remains unpaid after the expiry of 15 days following the receipt of the demand notice. So, on the expiry of the demand notice, since the cause of action for Section 138 NI Act offences arose after the company was subjected to a moratorium under IBC, the court held that the proceedings against the appellant cannot be sustained. So, if you observe, the proceedings cannot be sustained during this particular time period. So, you must file a particular civil suit during that only that respective time period. Only then it can come under this NI Act. Let me give you a question now. A company check to a creditor bounced due to insufficient funds. The creditor issued demand notice on August 6, 2018, but the company was under IBC moratorium from July 2025, 2018. That the creditor filed a Section 138 notice NI Act complaint against the company and the directors. The director sought to quash the proceedings, arguing the cause of action arose after the moratorium and was declared decided. Okay. The cause of action for the offences under Section 138 NI Act arises only after the expiry of 15 days from the receipt of demand notice. Okay. And since the moratorium was already in the place, the proceedings cannot be sustained. So if you observe very clearly, if it has basically been filed before the moratorium, then it cannot be considered. I hope this is very clear for you. Very simple, on to the point I've given to you. Learn the case name. It is basically Vishnu Mittal versus the Shakti Trading Company cases. Very simple. Now, sixth question. Pawan, who's basically in India, signs a deal with Kamal, who's basically in Colombia. Okay. The contract says Indian law applies, but arbitration will happen in Bogota. Since both newer mentioned which law governs the arbitration clause, the court presumes it follows the Indian laws because the main contract was under the Indian laws. So very simple. The contract says Indian law applies, but arbitration will happen in Bogota. Since both never mentioned which law governs the arbitration clause, the court presumes it follows the Indian law. So, for example, if Pawan, I am signing a deal with Kamal, who's basically in Colombia, and the contract very clearly have mentioned that we will be following the Indian law from now onwards. Even though if there is an arbitration problem, if it is happening in some other place, the court will still be applying what the Indian laws. So this was decided in which case Bisortho versus the versus the Merrill Life Science Private Limited case. So very simple. In an international commercial arbitration dispute, a contract between a Colombian and an Indian entity had conflicting clause. One subjecting the contract to Indian law with Gujarat court jurisdiction and another request requiring arbitration Bogota under the Colombian law. The petitioner sought an arbitration in India while the respondent argued for Colombian law due to the arbitration venue. Determine the most appropriate option. The answer is very simple. The arbitration agreement is governed by Indian law because the main contract is governed by the Indian law, and it is strong presumption in favor of the lex contractors when the law governing the arbitration agreement is absent. Okay, very simple. Now, seventh question. In a criminal trial, the trial court rejected an application under section 319 of the CRPC to summon additional accused. The High Court set aside the trial court's decision and wait, I'll just go to the example so it'll be easy for you. In a Pawan's case, the trial court earlier refused to summon Kamal as an accused. Later, the High Court ordered reconsideration. Even if the trial finished by then, the trial court can still summon Kamal because the High Court's revisional order relates back to the original pre-trial stage. So, for example, now in the trial court, what happened? In the trial court, in my case, Kamal was not called. Later, this case was basically being passed to the High Court. So, High Court resent. The revisional petition was resent back to the trial court. Now, what happened? Can the trial court call Kamal? Yes, he can call the Kamal. Okay, no illegality is considered under section 319 of the CRPC application after trial based on High Court's revision order. Supreme Court says it very clearly. Okay, very simple. So in a criminal trial, the trial court rejected an application under section 319 of the CRPC to summon the additional accused. The High Court set aside the trial court's decision and ordered reconsideration. After trial concluded, the trial court summoned the accused compliance with the High Court revisional order. The accused challenging the summoning order, arguing that the trial court lacked the jurisdiction and it became functious officio from the conclusion of the decide. Okay, the answer is very simple. The trial court can reconsider a section under section 319 of the CRPC application after the trial concludes if the High Court in its revisional jurisdiction directs it to do so, as the High Court order relates back to the original order of the trial court rejecting the application under section 319 of the CRPC. Okay, guys, next question. Next question, let's go through it. Very simple. Pawan owns 3 buildings but want to evict Kamal from one to start a clinic for his son. Kamal argues Pawan should use another building. The court says Kamal cannot dictate which building Pawan uses. The landlord is the best judge of the own bona fide agreement need. Okay, very simple. Pawan is having a 3 building, and what happened? Kamal is actually is one of the he's basically staying in one of the buildings. So I'm asking, I am the owner. I'm asking you to get out of my building because I would construct a clinic over there. But what happened? The court is like, the court is, can Kamal go files a case? How can Pawan removes me when he has already other building? So court very clearly said that Pawan is the owner of the building. He can decide what is right and what is wrong. Okay, very simple. It was in the case of Kantyala Lal Arya versus the Ishwan case. What happened? The Supreme Court observed that the landlord or property owner is the best judge of which portion of the rented premises should be vacated to meet the specific needs. But the tenant cannot oppose eviction merely on the grounds that the landlord owns the property. So this was in the case of B. The landlord is the best judge of which property to evict for bona fide need, and tenant cannot oppose the eviction on the grounds that landlord owns the properties. Very simple. Now, ninth question. Ninth question, if you observe, a property owner executed a G. Okay, I'll read the example first, then I'll go to this one. Pawan gives Kamal a GPA and an unregistered sale agreement to sell his property. After Pawan's death, Kamal sells it. So very carefully listen. Pawan gives Kamal a GPA. Pawan is giving Kamal whom? A GPA and an unregistered sale agreement to sell his property. After Pawan's death, after my death, what will happen? Kamal sells it. Okay. Pawan gives Kamal a GPA, general power of attorney, and an unregistered sale agreement to sell his property. After Pawan's death, Kamal sells it. The sale isn't valid because the GPA ended when Pawan died. And an unregistered agreement does not give Kamal the complete ownership. I hope this example is very simple for you. Pawan is basically giving Kamal, I'm giving Kamal a GPA, general power of attorney, and a general unregistered sale agreement to his property. So after my death, Kamal cannot use the GPA. And even because it's unregistered, this one property, Kamal cannot use it. Very simple. This was decided in which case? The Anathamurthy ANR versus the Manjula case. Very important case. Very, very, very important case. Please read it. The question we'll look into. Okay. A property owner executed a GPA and an unregistered agreement to sell in favor of an agent. After the owner's death, the agent sold the property to a third party. Okay. Now, what happened? He sold to the third party. The legal heir of the owner, original owner, later sold the same property to another buyer, who subsequently filed a suit for the possession. The agent claimed that GPA and the agreement to sell gave him the authority to sell the property. Even after the owner's death, find out the most appropriate portion. The answer is what? The GPA becomes irrevocable upon the owner's death if it is coupled with the property's interest, but an unregistered agreement to sell does not confer any property rights. So if it is not registered, you cannot hold the value for it. Now, 10th question. Before I read it, let's look at the example. Pawan mortgages land to Bank A through an unregistered sale agreement, then to Bank B with a proper title deeds. When Even though Bank A came first, Bank B wins priority because only a legal mortgage via the title deeds creates enforceable rights. Very simple. Okay, very simple. So even though Bank A comes, only Bank B would be given priority because they have the entire title deeds with it. Now, let me look at the example. Question. In a dispute between the two banks over the priority of charge on a mortgage property, Bank A provided a loan based on the deposit of an unregistered agreement to sell, while Bank B provided a loan based on the deposit of the title deed. Bank A claims priority because his mortgage is created earlier in time, while Bank B argues that the mortgage, being a legal mortgage, should be prevailing over Bank A equitable mortgage decide. So this was in the case of what? In the case of Cosmos Corporation Bank Limited versus Central Bank of India, it was decided that a legal mortgage created by the deposit of the title deeds prevail over an equitable mortgage created by the deposit of an unregistered agreement to sell, even if the equitable mortgage is prior in time. So very simple, guys. Please do prepare it. The most important kind of 10 important questions I've given to you. Learn it for your upcoming exams. Very, very, very important because judgment based questions, they're asking a lot. And I want all of you to give your time, space, energy, and prepare for it. All the details about the classes and everything, details, notes, everything you'll be finding in the below. And please do explore it. And I hope today's class was very interesting. Please do let me know how today's class was there. Wish you all the best. Good luck. This is me, Advocate Pawan, signing off. Take care. Goodbye.